Assalamualaikum and hi everyone. My name is Wanur Lydia Shazrin Bintuan Arifin, matrix number 280821. In this video, I am going to explain to you about the things under the topic International Regulation of the Use of Force. The first one is the prohibition of the use of force. Apart from being specifically stated in this article and alluded in several other treaties, it is now widely recognized as a principle of customary international law. The second one is the principles of non-intervention, which states that every state has the freedom to conduct its own affairs without interference from others. The third one is exception to the prohibition on the use of force and other forms of use of force, which is self-defense, humanitarian intervention, invitation and civil war, and protection of nationals and property abroad. Now that we all have an idea of what this topic is, let's move on to case studies. For the case number 1, we have chosen the military and paramilitary activities in and against Nicaragua, which involve Nicaragua and the United States of America. Let's learn some facts of the case. On 9th April 1984, Nicaragua filed a suit against the United States of America for military and paramilitary activity in and against Nicaragua. The application claims that, quote, the United States of America is using military force against Nicaragua and intervening in Nicaragua's internal affairs in violation of Nicaragua's sovereignty, territorial integrity, and political independence, as well as the most fundamental and universally accepted principles of international law, end quote. Please pause the video to read more on the facts. Now, I bet all of you want to know what were the principles of judges regarding number 1, prohibition on the use of force. The court ruled that the US breached its customary international law obligation not to use force against another country when its involvement with the contras resulted in the threat or use of force. The US violated the customary international law prohibition on the use of force when it planted mines in Nicaraguan ports, attacked Nicaraguan ports or installations and a naval base, and aided the contras by, quote, organizing or encouraging the organization of irregular forces and armed bands for incursion into the territory of another state, end quote, and participated in, quote, acts of civil strife in another state, end quote, all of which involve the threat or use of force. Number 2, the principles of non-intervention. The court ruled that the US violated its CIL responsibility not to engage in the affairs of another state by training, arming, equipping, and financing contra troops, or encouraging, supporting, and assisting military and paramilitary acts against Nicaragua. Last but not least, self-defense. The court held that the US could not justify its military and paramilitary activities on the basis of collective self-defense. The court ruled that the necessity and proportionality requirements which must be met when using force in self-defense were not fulfilled by the US. The requirements are: a state must have been the victim of an armed attack, the state must proclaim itself a victim of an armed assault, in the case of collective self-defense, the victim state must request for assistance, and a state that is attacked does not have the same obligation as Article 51 of the UN Charter to report an armed attack to the Security Council.
Next, I will explain about the provisional measure in this case. On 10 May 1984, the Nicaragua has proposed for further provisional measure at the ICJ against the US. This is because the Nicaragua, they believe that the US has violated the obligation under the Article 2.4 of United Nations and the Article 18 and 20 of the Charter of the Organizations of American States, as well as towards the general and customary international law. As for the proof, the Nicaragua government has found that the American Congress budgeting $24 million to support overtly and covertly the military and paramilitary activities in the Nicaragua. Not only that, the US also has instrumented mercenary army of more than 10,000 men and have resulting into the death of 1,400 Nicaraguans. The requested provisional measure made by the Nicaragua against the US is the first one: US should cease from supporting, financing any group or organizations and desist in engaging in the military and paramilitary activities in Nicaragua. Second, US should stop military and paramilitary activities of its own official in the Nicaragua. And the third one is US should refrain from the use and trade of force in relations with the Nicaragua. To wrap up the first case study between the Nicaragua and the US regarding the regulation of the use of force, this case ended with discontinuance. This is due to the fact that Nicaragua informed the court that the two countries has reached agreements aimed in enhancing Nicaragua's economic, commercial and technical development to the maximum extent possible.
Next, we'll be discussing on case concerning arms activities on the territory of the Congo, which is Democratic Republic of the Congo versus Uganda. The Democratic Republic of Congo (DRC) asked the court to decide that starting from 2nd August 1998, Uganda had engaged in arms aggression in the DRC. They argued that first, Uganda had engaged in military and paramilitary activities against the DRC. Second, Uganda committed and failed to prevent violations of human rights and humanitarian law. And the last one is Uganda engaged in and failed to prevent the illegal exploitation of Congolese natural resources. Facts of the case. With the support of Uganda and Rwanda, President Kabila ascended to power in the DRC in 1997. Ugandan and Rwandan soldiers were first present in the Congo as a result of the DRC request and agreement. The DRC ties with Uganda and Rwanda worse, and ultimately President Kabila announced on July 28 in 1998 about the withdrawal of the DRC consent to Rwandan military presence in the DRC. Kabila also accused Ugandan and Rwandan armies of invading the DRC on August 8 in 1998. And in June 2003, Ugandan military withdrew from the DRC. DRC argued that Uganda occupied DRC territory, while Uganda argued its presence in DRC was justified due to several factors, which is based on DRC invitation from 11 September 1998 until 10 July 1999 based on self-defense. And last one is from July 1999 until June 2003 based on DRC consent.
Next is on the principle of judges on case concerning armed activities in the territory of Congo. The first one is self-defense. Uganda military operation in August 1998 and 11 September 1998 until 10 July 1999 could not be justified as self-defense. This is due to the fact that its military operation have not received consent from the Congo, and this situation instead gave the right to self-defense to Congo. The Uganda also failed to meet the condition in Article 51 of the United Nations Charter. In order to rely on this said article, Uganda had to demonstrate that it had been subjected to an armed attack by the Congo. However, there was no proof of the Congo involvement in those armed attacks. The next one is the principle of non-intervention. Ugandans have engaged in an unlawful military intervention in Congo, and this intervention was a violation of the prohibitions on the use of the force under Article 2(4). This article provides that all states are prohibited to use any force at any state. Next is on the issue of occupation by Uganda's military in Congo. Uganda argued that its military personnel acted contrary to the instruction given to them and also have exceeded their authority. Hence, Uganda could not be held responsible for those acts. However, the court disagreed, as the conduct of any organ of a state is to be regarded as an act of a state itself, even if the organ have exceeded their authority. Hence, Uganda is responsible for the act of Uganda military forces and its individual soldiers. The International Court of Justice have ruled that Uganda have violated the international principle of non-use of force and also non-intervention with its armed activities between August 1998 and June 2003 under Article 2(4) of the United Nations Charter. To conclude, cases such as Nicaragua versus United States of America and also Democratic Republic of Congo versus Uganda, both the cases have shown the international regulation of the use of the force under Article 2(4) of the United Nations Charter. While it is true there are some exceptions to this prohibition, we also must keep in mind that any illegal intervention or armed attack without any plausible explanation is a grave violation to the international law. That's all from us. Thank you.